supplementary list, item number 1.
Your Lordship, may I pray that this matter may come up at the end of the board?
Also,
Item number 2.
Mother, I'm not able to hear anything.
you have not said anything. No words have been spoken, so how can you hear? Now, can you hear?
No, I can hear.
Yes, Mr. Pandit.
Yes, my lord. My lord, I will confine myself to the pleading, to the petition. I will not go and I will not try to mislead also. My lord, I will rely on one judgment first, that is 1995, 1 Supreme Court, that is Daulatran.
Must be a copy.
Para?
That is para number 4, my lord. It says that rejection of bail in a non-bailable case at the initial stage and the cancellation of bail so granted have to be considered and dealt with on different bases. Very cogent and overwhelming circumstances are necessary for an order directing the cancellation of bail already granted. Generally speaking, the ground for cancellation of bail, broadly illustrative and not exhaustive, are interference or attempt to interfere with due course of administration of justice, or evasion or attempt to evade the due course of justice, or abuse of concession granted to the accused in any manner, the satisfaction of the court on the basis of material placed on record of the possibility of accused absconding is yet another reason justifying the cancellation of bail. However, bail once granted should not be cancelled in mechanical manner without considering whether any supervening circumstances have rendered it no longer conducive to a fair trial to allow the accused to retain his freedom and by enjoying the concession of bail during the trial. This is the position of law, my lord. Then, my lord, I will just one judgment from the Delhi High Court. My lord, page number, last page, paragraph number 60.
Page, para 16.
Yes, my lord. I am in agreement with the submission made on behalf of Manish Goyal that non-appearance for investigation on 1 or 2 dates cannot be ground for cancellation of bail. It is an admitted position that after grant of regular bail, Manish Goyal did appear before the authorities pursuant to summons received by him on various occasions. Therefore, the order dated such and such passed by Session Court cancelling bail on account of non-appearance on 1 or 2 dates is harsh and is accordingly set aside. However, it is made clear that Manish Goyal shall strictly comply with the condition imposed by such and such passed by the learned SG. Though this court is confirming the bail granted to Manish Goyal, he is warned that in future, if he does not appear pursuant to summons issued by DGGI, his bail would be liable to be cancelled. However, the DGGI shall give notice of at least 48 hours to appear pursuant to the summons issued. Now, my lord, I will take my lord to the case in hand. This is one chronological date of event I have prepared, my lord. Now, my lord, on 19/9/2024, accused appeared and a statement was recorded. Necessary formality took place. On 8/10/2024, page number 37 of the petition, my lord.
Yes.
Page number 37. Notice for production of original document was required by the IU. But the same dispatch. This notice, my lord, if your lordship will see, this notice was issued after the date was already over. The first notice, I am replying to all the notices. The first notice, it is in page number 37. This is for production of original document. So my lord, this is, it was, I was asked to produce the document on 1810, last paragraph my lord, 1810-2024. Date was fixed. This WT message we are not aware. So this WT message, it was never served upon us. So the first notice is on page number 37. So this is, it was fixed 1810-2024, production of original document. My lord, next page, this notice was dispatched on 2210, after the date was already over. 2210-2024.
Okay.
Now my lord, this is one thing, one summon. It was only for production of original document. Now my lord, page number 40. Page number 40, my lord, there is nothing that it was served upon me. No pleading and no receipt, nothing is there. So it has no bearing. Number 41. Page number 41.
40 you says?
Page number 40, that is one notice, another notice was issued. This
41A?
Yes, my lord. It is on 21st October 2024.
Yes.
So it was issued, but when it was served, it is not served upon us. We are not, there is no evidence also in the petition itself. So now we are concerned with page number 41, my lord. That was notice, it was served. That is 41. This notice was issued on 25/11/2024. This notice was, again, it was asked to produce the original documents on or before 10th, last paragraph, my lord, 10/12/2024. This notice, it was served upon us, and accordingly, my lord, there is receipt also. Accordingly, my lord, on 7th, before due date, on 7/12/2024, which is evident from, my lord, page number 43. Page number 43. This notice was received by the advocate, and on the same day the document was produced. This notice was issued for production of the original documents on or before 10th. So my lord, on 7th the documents were submitted, and the same was seized, my lord, which I have enclosed in my chronological dates of event, that is seizure list. It is there. There is no dispute, because this notice was again issued for this 43, page number 43. This notice was issued on 7/12/2024. So my lord, there was condition by this honorable court. My lord, the IO again put many conditions. Kindly come to, my lord, this notice itself, 43. There are many conditions which the IO put, and this number 1, my lord, is that you will not commit any offence in future, and number 6, my lord, you will disclose all the facts truthfully without concealing any part relevant for the purpose of investigation to reach to the right conclusion of the case. These are the condition, extra condition he has put.
Mr. Pandit,
No, my lord, this one
Just-
is,
just a
yes,
moment.
yes.
when were you granted bail?
Bail was granted, my lord, on absolute, it was my lord, it was granted on
24 September.
yes, my lord. October notice was issued. September,
After, you see, after bail is granted to you,
yes, my lord.
can notice under section 41 still can it still be issued?
No date, no, my lord. Even if the date notice cannot be issued, but date has to be intimated where I have to appear. So they were communicating that you have to.
You are not on that.
My lord, yes. I am not on that also, my lord, because 41 may not required, because the IO will call and then we have to go.
Exactly.
That is,
That
but
is
the
what-
IO has to intimate us.
That is the query of the court.
Yes, my lord. Yes,
When the bail, you see, has already been granted,
yes, yes,
conditions have been stipulated.
yes, yes, yes.
One of the conditions is for you to appear before IO.
IO as and required.
IO, yes, as and when required, he will intimate you,
Yes,
but not necessarily by issuing a notice under section 41.
but as per the pleading, my lord, they have issued. That is
They
there.
have issued? I
Yes,
thought
yes,
see-
yes. It is not required. It is not required, but they were intimated, because I am resident of Rajasthan, so they
Because
have.
you see, what would be the consequence of non-compliance with issuance of notice,
Yes, my lord.
it will entail arrest
Yes, my lord.
on order of the magistrate.
Yes. Yes.
So then when you are already granted bail in that case,
Yes.
how can you be arrested? That's just a query.
Yes, then this notice was issued on, my lord, page number 43. The IO directed us to appear on, that is the crucial date, on 17 January 2025. All along original document we have produced on the summon, and on this date, my lord, he has put these conditions, and he said that you have to appear, again issued notice 45, page number 45. This is the notice was issued for our appearance on 17 January 2025. 17 January 2025 was the only date, your lordship. Yes, this is crucial. On this date, your lordship, 17th was the date fixed for appearance. So, my lord, he has said in earlier notice that if you have any problem, then you have to communicate me. That is evident from page number 44 also. He has said so, that if you have any problem, then you have to intimate me. So, my lord, on that day, 17, it was date for appearance. Then on that day, my lord, on 16, I was fell sick. And that notice, my lord, I have enclosed with my chronological date of event. It is there, my lord. It was intimated to the IO, and which is evident from his status report also. That
16.1.
Yes, 16.1 we have intimate him through phone, and even we have sent the medical certificate, enclosing the that on such and such we are not be able to appear, and you will appear on subsequent date. So, my lord, on 16 intimation was there. So, my lord, and the medical certificate is there. I was having some ailments, so there was rest was required. So, my lord, there was on multiple cases. On this is evident from the status report also, my lord. On 16th February, my lord, after 10-15 days, there was my presence was also required in Khanapara PS case. So, my lord, on 16th February 2025, I went to the Khanapara police station. Till that time, no date was fixed in this case. So, on 16/2/2025, I went to Khanapara police station, and there, my lord, another case was registered. I was brought to Tura again on 16 itself, and this fact was well within the knowledge of this IO, present IO, which he has indicated in his status report also. He did not came and examine me because I was there for 2 days. I was arrested in connection with one case, that is Tura woman PS. POXO case was also inflicted on me, and thereafter, my lord, on 17 another case was registered at Ampati. It is also evident from the status report. So, my lord, on 18th till 18th, I was there, I was released, and thereafter, my lord, I went back. From 18th to 2025, there is no communication. There is no, it is also evident from the record also, my lord, no date fix, nothing was there. And subsequently, my lord, we came to know that the IO has also been changed. So, my lord, only on one date, that is 17 January 2025, if we consider this petition, which I was handicapped in appearing, and for that intimation was already given, my lord. So, my lord,
So 17/2 is the
17 January.
Oh, January.
17 January, my appearance was required by the IO.
No, but 16 January you have already intimated that you are sick.
Yes, on 16, one day before I intimated,
Then?
because 17 was the date.
But that was acknowledged.
Yes, I was having knowledge that it was intimated to the IO.
The IO has acknowledged that you are sick.
Acknowledged in his status report
Okay.
that I was making an excuse that intimation is not in dispute, but he said that I could not appear because in status report that it is written here that giving excuse of medical. So that means intimation was there on 16, only on that day, my lord. And thereafter, my lord, there is no communication and no date is fixed when I have to come. So only on that one date, my lord, which has already been intimated as per the petition. So my lord, only on that ground, cancellation of bail will be very harsh, my lord. And my liberty may not be compromised only on that day. And my lord, production of document, it is also admitted that I have produced all the original documents. I have produced all the original documents. So my lord, on this ground, my lord, which has been mentioned in the petition, no case, your lordship, is made out for cancellation of bail at this stage. My lord, I am ready to, again, if the date will be fixed and if place and where I have to come, I will appear. Only one chance may be given, my lord. No harm, no prejudice will be caused to the prosecution at this stage, my lord. So there is no case made out, my lord, on these facts and circumstances. So only because, my lord, there are multiple cases. A condition of person has to be, circumstances has to be seen, my lord. That where I will go. One case is here, another case, when I appear there, then two cases they are filed in another district. So in such circumstances, it is difficult for me, my lord, for my movement. So in these circumstances, my lord, some accommodation may be given at this juncture, my lord. There is no dispute that there is only one case. Multiple POXO cases has been inflicted. It is evident from their petition itself, my lord, that page number 46, that FIR has been registered on 18th, on 16/2. So only for 15 days, my lord, I was sick, and thereafter I was available. But so many multiple cases again came into picture. So no case, my lord, is made out for cancellation of bail at this juncture. A warning, I will be appearing as and when the intimation is given to me, the date, my lord. I will not escape. And there is no, this is not a case of absconding, my lord. This is not a case of absconding. A regular touch communication was there. So only on this.
If I may, my lord. My lord, let me start with the last one. Regular touch communication has not been there. In fact, we have no clue where he is. We have been sending it at the address that has been provided, but his whereabouts are not known. We were told that he is moved to Hyderabad from the Jaipur address. So he's actually absconding. He has not been cooperating at all. As clear from the status report, he has only appeared once. That too, my lord, he had first made a false statement before my lords. Even before the bail was made absolute, after the interim bail was granted, he was asked to appear before the IO. He did not appear himself. He sent someone else. He sent photocopies of documents. At that time also, it was constantly being said that no, he appeared and he has produced the original documents and he has a signature of IO, etc. But he had not appeared, and only when the court again reprimanded that he appeared. Once the bail order was made absolute, he has never ever appeared before the IO. I can take my lords through. The council had begun saying he won't mislead, but I can take you, my lords, through the documents. Maybe there is a mistake in looking at the documents. If my lord may come to page 37, the fact that this was not sent after so page 37 is a notice dated 8th October 2024, where he was required to produce, and my lord, we're just asking for the original documents, and even if that cannot be produced,
No, it has been
and they
produced.
say that no prejudice has been caused and will be caused, enough prejudice has already been caused. The complainant has died.
Anyway, whatever the case may be, he said in due course these documents were produced.
My lord, it was not produced. They haven't been produced. My lord, may come to the status report. They haven't been produced till yet.
But
It
he
is
was
there in
saying
the
that
seizure list. He
My
is
lord,
silent.
Just
it hasn't been produced. I'm very sorry to say that.
No, देती है.
If my lord may see second last paragraph, the case is kept pending with no further development as the accused is not cooperating, and the missing document or files shows between 2018 to 2021, etc. shows all of this. notices under so and so was served to the accused on 25th November to appear before the police and to produce document in connection with the case and to appear before the court on 14th November for recording handwriting specimen. On 7th December, advocate so and so came on his behalf and accordingly notice under 41A was served through advocate so and so to appear before the police and to appear in Tura court, and he had already failed to appear. So, my lord, there is no mention of original documents being received through that.
I have produced the seizure list. Seizure list, he is silent. Entire pleading, they have not said that the original document has. In the status report also, they have not said that original documents. As per the notice, my lord, 37, page 37, all the document which is mentioned here, we have produced. And the seizure list is very much here.
Where is the seizure list?
In my chronological dates of event, my lord.
No.
My lord, I can get the
He is silent.
The
Seizure
list
list.
has to be. I'll produce it because I don't know what chronology they have produced.
Yes, this seizure list,
I have
your
given
colleague will
copy.
have this copy.
The copy, Lordship.
Yeah. This one.
Lordship, well, as my learned friend stated, Lordship, if your Lordship may allow us to get a copy of the case diary, Lordship, and
No, but I cannot mislead the court. Like seizure list is there, and he is silent about the status report.
The case diary because
That in the pleading also they have not said, my lord. In the pleading also they have not said that I have not produced the documents.
Yes, this seizure list was made on 7th
7th, when he appeared, the advocate appeared.
December.
I'll confirm. I'll get the case diary.
But here is
As
the
per
copy.
the
Here
status
is the
report
copy.
says
You don't have a copy of this.
I have given here, my lord.
my colleague would have it, but I'll definitely check with IO and get back on this. I'll get instructions.
No. My
We'll have to check the case diary. My lord, if it
You see,
would
you see
have
what
been
what is
then
see
the status report-
now what is required here, as far as the court is concerned, is to look into the bona fide
Yes, ma'am.
of the respondent.
which is completely absent, my lord.
So you say absent, he says present, so we'll have to cross-check
Yes,
facts.
My lord. I'm relying on two Supreme Court orders in a similar circumstance where the accused failed to produce documents, failed to appear before the IO. The bail was cancelled. So
He was citing, Mr. Pandit was citing only one instance where he says because of his sickness, whatever, that is 17/1/2025, where he could not appear. That is admitted.
before that, he hasn't ever appeared anyways. The order was
Before that,
made absent
see, he was
in
saying,
September.
just a moment, before that, as far as that 16/1 is concerned, he was sick. So intimation was
Given.
made to the IO, acknowledged.
Madam.
So, and he has given this, yes, this list of, you have the date, Mr. Roland.
Yes.
Lordship.
You check this thing. You go through this list of dates and check with your records.
Lordship.
No, let them
Cross-check.
give any document they give from here on, whatever response they file, let them file it on an affidavit, because that's what this honorable court had asked them to do, but it has not been done. Rather, a loose paper is being provided. If it would have been, it has to be on an affidavit, because they have been doing this since the beginning. It's not on the council. They have been coming through different councils and making all sorts of false statements.
Whatever the case may be, if you say so, the court will call the case diary,
Yes.
and all these things will be available there.
Yes, ma'am.
Should be.
Yes. It has to be there.
The seizure list,
Yes.
then these medical records
Yes.
and the correspondence
Yes.
will be there.
Yes. Because, my lord, only one date that is very crucial, and I have intimated.
Okay, we'll see.
Yes, ma'am.
When can you do it?
Lordship, this.
Well, let me keep it 8th.
On 8th.
Lordship.
8th of August.
After next date 8. In the second week, my lord, if it is possible, after 15th August.
11, 11, 12, 13, any, up to you. Which date do you want?
14 Independence Day will it will be difficult. 13.
13 is a Wednesday, so
All right, any convenient date. 11 also no problem, my lord.
11, 11.
Yes, my lord.
Kan dijadikan kemudian. Heard Mr. S. Pandit, letter counsel for the respondent. Also heard Ms. C. and Leonard G.A. for the state petitioner. And yeah, next. In the course of hearing, the Leonard G.A. has submitted that since the respondent has referred to the seizure list as well as other materials which have been produced at the bar today, it would be necessary for the prosecution to confirm the authenticity of such assertion, which can be done so only on production of the relevant case diary. Accordingly, as prayed for, let the case diary of which case?
Arrival PS case. Arrival PS case number
Arrival PS case
25
85
bracket 5 of 24. 25/5/2024.
be produced for this court on the next date fix. It's agreed to by the parties. Place this matter on 11th for further hearing. 11th.
On daily list, item number 1. Second call from supplementary list, item number 1.
My lord. Call for him.
Your Lordship, Leonard DSJ is still on legs before DB.
So later,
My lord, end of the board.
end of the board.
On daily list, item number 1.
May it please your Lordship. Your Lordship, during the pendency of this instant writ petition, there were subsequent developments that has arisen, whereby the petitioner here was removed from the office by the order and notification duly issued by the respondent district council. Your Honor, I have the copy. Lordship, in view of the fact that there is a subsequent development, it gives a new cause of action arises whereby I intend to challenge the order that is passed. So in view of my humble submission, I humbly pray that I may be allowed to withdraw this instant writ petition with liberty to file afresh, Your Lordship.
Mr. Leonard Counsel for the petitioner has submitted that in course of these proceedings, an order dated 3/7/2025 was issued by the Executive Committee HADC, by which order the petitioner was removed, suspended, or what?
Removed, Your Lordship.
Was removed,
Yes, Your Lordship.
as
Same.
As the same.
same
Yes, Your Lordship.
as the same of
Nongspung same ship. Your
Hima
Lordship.
Nongspung to Hima Nongspung under bracket Nongspung same ship. It is the submission of the learned counsel that under such fresh developments, the petitioner contemplates to resort to fresh course of action. It is therefore prayed that this petition may be allowed to be withdrawn with liberty to file a fresh one. Mr. Learned Counsel appears for the respondents.
For 1 to 3, Lordship.
Accordingly, as prayed for, petition is hereby dismissed as withdrawn with liberty sought for allowed.
Much obliged, Your Lordship.
Petition disposed of.
Item number 2.
Item number
Yes,
3 may be taken.
Why has this matter come up today?
My lord,
Lordship will recollect the issue was whether 27A was added,
Oh, 27A.
and we stop at the point whether can he produce a judgment to show after the charge has been framed and 2 witnesses have been examined. Can the issue of 27A of the NDPS Act, Your Lordship, imposes the rigor of 37. He read out
That
the
is for
FIR.
financing and all those things.
My response was that you can argue 27A only before argument before charge, not 227. He has missed the bus and the trial has proceeded. So 2 witnesses have been examined. So only limited ground was, and he was arguing very vehemently that 27A is not covered. So the issue was, can in a bail application, can the issue of 27A be decided? We stop at the point where he was asked to submit a judgment, if there is a judgment on that issue. If not, prima facie it's a case of multiple FIR, period of detention order also.
So if we consider the presence of 27A,
Right.
then the whole case comes under the purview of, or rather, Section 37 is subtracted.
Absolutely. No,
And you go back,
no. Can we go back?
while considering the issue of bail, then the provision of Section 37 has to be looked into.
Absolutely. And the requirement of 37 is this: if there is a subsequent offence committed, there is a clear bar. And in this case, there are 2 cases.
Yes.
So that part, prima facie, we are not. It's against him. The only issue was, can in a bail application 27A argument be forwarded? Especially, and my response was, it can be done only in the framing of charges. If he succeeds, the charge would have not been framed. Now that has flown through. 2 witnesses have been examined. He was asked to specifically come today to have a judgment on that.
my lord, there is no such judgment, my lord, which prevent or which restrict a court that the court at the bail stage cannot look into the circumstances. There is. I tried my best, but there is nothing.
We are not on that.
Yes, my lord.
The court can definitely, any court for that matter,
Yes.
can consider your bail application
Yes.
as and when you have filed it. But the only question here is, as Mr. Khan has said, your bail application now will be considered, looking into the fact that Section 27A is present.
Present.
That much.
Yes.
But since you were insisting that we do away with Section 27A,
And then I will escape from
then
rigor.
there are other consideration for that.
Yes.
But in the presence of 27A, which, as Mr. Khan said, could not be the subject matter of this court, you have not come for quashing of
Passing or challenging that said charge.
challenging that charge.
Yes,
So,
yes. No, my lord, unlike in civil cases, where a party is barred by waiver or something. But in criminal cases, my lord, as far as my point of argument is that, my lord, there is no bar. The court cannot turn a blind eye, my lord. Even though, my lord, material is there and then there is no case made out at all, then also the court, my lord, the honorable court cannot turn blind eye that no, since you have not argued before charge at that point of time, you have waived your right or you cannot raise this point. So bail, consideration of bail, it is a continuous course, my lord. At any point of time, I can even bring new grounds and the court may take into consideration. So admittedly in this case, my lord, only the thing is that a small quantity of contraband recovered from my possession. And my lord, 27A from the material, though I have missed the bus, it does not mean that I cannot catch again, my lord, in this type of cases.
Okay.
In this type of cases, bail. So, my lord, I have pointed out that this section 27A was invoked only to stop me from getting the bail.
So, Mr. Pandit, just a moment, so that we can cut the discussion
Yes,
short.
my lord. Yes, my lord.
In this application,
Yes, my lord.
have you mentioned anything about the vice of section 27A? You have not come against the fact that section 27A was inserted or came later.
No, it was from the beginning.
You have not said that.
No, I have said, my lord, that it is from the beginning.
There's
only.
nothing in your prayer for that. Since you have cast the onus on the court.
Yes, my lord.
That the court cannot be blind
Yes,
to the fact situation.
Yes.
And if the court perceives
Yes.
or detects
Yes, my lord.
that an illegality or irregularity has been committed by the trial court,
Yes, my lord.
this court can correct.
Yes.
But again, as Mr. Khan has pointed out, that can be corrected only by a proper application. Number one,
397.
Specific prayer.
Yes.
And and the proper provisions of law.
Yes, my lord.
Section
I agree,
482
my
for
lord.
that matter.
Yes.
So if you had come under those,
Yes,
that kind of petition, perhaps.
Then yes, but that
and even you see, because if that issue is dealt with first, and the court say yes, the trial court cannot do it.
Yes.
Then the next round, the next course of action for you is to file a bail application, which will be considered in the light of any order passed, previously.
Yes.
So that you.
No,
that
I
is
have
missing
not challenged
altogether.
that one. I have not challenged.
You have
my
just
lord.
come,
Yes,
with
just-
a bail application simpliciter.
Yes. So even
So
though
in that case, you see, then I have to, rather this court has to take into consideration section
tentative
27.
evaluation may be, my lord, can be made. Tentative, not I am saying that the court will go into the depth, into the merit and this one. Tentative evaluation can be that this
But
27
even
is
then, you see,
doubtful.
Even then, the court cannot do, because it's there. You see, you cannot do it away. It has been inserted, it's there, and if it is there, it attracts section 37. And if it is 37, then you have no case.
No,
Frankly speaking, you have no case.
my lord, even if suppose 27, if it can be assumed that it is there, then also, my lord, I have to satisfy this honorable court that material on record, I am innocent. That is the one of the condition.
Yes.
37. That reasonable ground is there to believe that I have not committed the offence. Offence only with regard to one particular offence, that is 27A. So even though, my lord,
But as you have also,
another case, that
there's
another condition I
so
am unable
that
to satisfy. So now taking into consideration, my lord, that I am behind the bar for a small quantity, it is there, and for 10 months I am there. 2 witnesses has been examined, and my lord, 2 witnesses has been examined at this stage also, my lord. In the trial also, with these 2 witnesses, it has come that section 27 does not attract, even though that time it may be attracted. But now, since 2 witnesses has been examined, this this consideration, this honorable court may take this note of this.
But you see, what is the relevancy of those testimony of those documents, of those witnesses.
Two witnesses.
Whether they are directly connected with the issue of 27A, or they just seizure witness, or they just
He is the informant,
FIR
complainant.
writer, all those things.
He is the complainant, the
He is
one who
complainant.
has
So
been
he
examined.
He has written the FIR. So at that point of time, question of 27A is not there. So all these things has to be considered.
So, my lord, my submission will be that only, your lordship, that even at this stage, that can be done. That can be done, because taking into consideration the whole circumstances and taking into consideration the quantity involved, my lord, I am entitled for bail in this new case, because I tried my best to find out, because this issue has never come that after charge sheet, still the argument can be made regarding the ingredients.
No.
That has not. I tried my best also, but
At the
I
time
did
of
not
framing,
find any
at-
such
where,
judgment also.
can you give me a copy of those charges?
Charge. Framing of charge, my lord.
The order of the court.
Yes, yes.
Where's the format?
This is the order.
Where is that form?
Form
of charges?
that charge. That one I have applied for certified copy. I could not get today.
No,
On
because
that day itself, I applied.
I just want to know when the charges were framed.
Yes, my lord.
Charges were framed,
On two
one,
head.
some, section
Yes, yes, yes,
21B.
yes, yes.
Number 2, 27A, it's there.
It's there.
So,
The
exactly.
order is elaborately discussed here, my lord. This is the discussion of the learned trial court, that how
So
27.
you see, Mr. Pandit, you were not prejudiced. You were not prejudiced when the charges were framed, because if
That time I was.
if at one go,
Yes, my lord.
you see, charges under section 27A was also framed,
Yes,
which means that you have given enough
Opportunity.
opportunity
yes.
to
Raise the
argue
point.
for charge and all
Yes,
those things.
yes, yes.
I thought that first charge was framed under 21B, then later on another charge framed under 27A.
No, no, no. At the same time.
Yes, 21B and 27A.
27A. That time we have not argued and charges were framed. So that's what my senior also said, that you have missed the bus. So only the thing is that, my lord,
Where's the copy?
my
You have copy of the charge sheet is here.
charge sheet is here, my lord. I have enclosed the entire evidence of all the witnesses. It is in page number 22. It is running from page number 22, my lord. And the statement of all the witnesses start from page number 27.
Yes.
So a statement of all the witnesses recorded under section 161. Also, my lord, if I will read, then there is no question of section
It's a matter
20.
of trial.
Yes, my lord. That's what a tentative observation may be made, my lord, just for purpose of bail, without going into the merit that this section 27A is questionable in the instant case.
Currently. Mr. Khan, what is the prima facie evidence as far as 27A is concerned?
In this order?
No, from the
charge sheet.
charge sheet. It has to be there in the charge sheet.
Page number 27.
25.
That is from
It's running from the witnesses 27. Page number
page 14.
27. Statement of the witnesses running from page number
21. It starts from 21. Or
Yes, that is the form. But 27.
So seizure was 37.28 grams.
No, my lord.
That page 17,
Page 7.
prosecution story.
This is, my lord, bail application number 37. We are dealing
Yeah, no,
because
36.
37, my lord. Bail application 37, because this is in 36, my lord. There is no 27A.
specifically on 27, we find it page 40, prima facie. After discussing from page 21 to 39, therefore, under the above facts and circumstances, the prima facie case against 21B, 27A on the top, Lordship.
Yes, but where are those facts?
Where are those facts?
Lordship, under above facts and circumstances, we have to go through in detail, Lordship, from
Because
page.
you just point out this, for example, just one instant where she is, seen to have given money, received money, or whatever. Just a moment.
Open 27 once, please. Open 27. Cancellation. Sure. May one see. Whoever indulges, tell me what he can. Whoever indulges in Lordship, 27 prima facie, Lordship, if I may just assess the court. 27A says whoever indulges in financing directly or indirectly any of the activities specified in so and so clause of section 2 or harbors financing directly, indirectly. Now, issue of financing will come in the stage of trial, or harbors any person engaged in any of the aforementioned activities.
Who was she harboring?
Lordship, we come straight to page 25. It will directly not come with, we have to read, Lordship, a bit of fine tuning will be required, but harboring here will come. The activities was supported by, you just come to page 25.
Yes.
In 2, clause 2, house search, from the bottom 1, 2, 3, 4. From the bottom, Your Lordship, para 2, the 9th line, that Srimati Noor Jahan Begum so and so, alias so and so,
Just a moment. Yes.
1, 2, 3, 4, 5, 6, 7, 8, 9. 8th line, that then Srimati Noor Jahan.
No, this is with regard to the container found.
No, Lordship, if you have read the whole sentence,
Yes.
so and so kept, that Srimati Aisha Khatun alias so and so kept one container near her shop in the morning and told her that she will take it in the evening. Container was kept with her and she'll take it in the evening.
See, Mr. Khan,
Lordship.
please,
Accordingly,
please educate me.
Lordship,
When the term harboring is used, it refers to inanimate objects or a person.
yes. No, that's why, Lordship,
Keeping a container of some alleged.
Lordship, my submission would be finance directly, indirectly, harboring. The container was kept with Noor Jahan. Aisha's container was kept in Noor Jahan. Noor Jahan gave it back to her. She took it, and then when this was seized in this container, the heroin was found. 40 vials. So this is prima facie, Lordship, this part of it, whether finance was involved directly, indirectly, whether in the activities. Now, if you read again, Your Lordship, or harbor any person engaged in any of the aforementioned activities. Any person engaged in any of the activities. 27A has got two components: financial activities directly, indirectly, or harboring any person engaged in any activities. Now, this container was with Noor Jahan, belonging to Aisha, and this was seized. So, prima facie, Your Lordship, an element of 27A is there. Now, we have to, at this stage, because it's a very lengthy charge here, Your Lordship.
Where is the the statement of Noor Jahan?
Yes, Noor Jahan's statement. Page 31.
31.
PW.
31. Page 31, PW2.
Yes. What did she say?
On examination, she stated that her name and address is true as mentioned above. She stated that she has been staying in so-and-so Shillong for a long time and running a betel nut shop at so-and-so. On examination, she stated that the house of Shri so-and-so adjacent to her shop. She has known Pahari and her children for so many years. She stated that most of the time Pahari used to stay in Assam. Recently, Pahari returned to Shillong and stayed in the room adjacent to her shop, and Pahari informed her that she has to go to court to hearing. Further, she stated that on so-and-so morning, so-and-so came to her shop and keep one small container, white color, under her shop and told her that she will take it back in the evening. But when the police came and searched Pahar room, they found drugs. She told the police Pahari had kept a small container inside the shop in the morning and did not take it back. On checking by the police, they found a drug inside the container.
See, by no stretch of the imagination can you say that this constitute elements of harboring.
Lordship, the activities, that's why I said, or harboring by any person, activities involved in it. It's a matter of interpretation, Your Lordship. Your Lordship, reading only isolates the statement of Pahari Noor Jahan may not be clinching. But prima facie, we find that the container was with her, belonging to the accused, and that was seized from her place. So basically, she was involved in an activity.
Well, then this Noor Jahan should have been booked.
Yes.
Lordship, that is, if these arguments are forwarded, Your Lordship, then court will have to take cognizance of that.
No, she has to, because
She has to be, yes,
she
yes.
becomes,
It's for the prosecution.
She become complicit in the
Absolutely, Lordship. This will be the role of maybe the trial judge or the prosecution when there's examination to implicate her as an accused.
See, the fact that she has not been made an accused, then there's no link as far as the harboring part is concerned. You cannot connect those dots.
No, Lordship is correct. But once we are reading this part here, it is for the prosecution at the time of this, whether this will, and that power is always with the trial court.
That, of course, that is. We are not talking about the trial.
Absolutely.
There,
But
see,
we
the observation is made on the basis of records only.
Absolutely. But what emerges from the charge sheet and the statement, Your Lordship, is that she has made a statement, the container with her, and Ayesha Khatun, the accused, was involved in drug activities.
Maybe.
She has got a checkered history of being involved in drugs. She kept the container, and the activities was harbored. Now, Lordship, simple, not that we're doing a final hearing, but simple meaning would be the activities of the accused in dealing with his drug was harbored by whom? The financial activity. Now, that the financial activities, whether money was paid or not, this will come out in trial, Your Lordship. We haven't gone through it whether what money was involved or not.
Do you have any authority on Section 27A?
No, Lordship.
Nothing. No description of what constitute.
No, there if the financial transaction, if I have finance to somebody, that is the only, I have gone through judgment that if the accused is continuously, not one isolated transaction, if she is continuously, that because that will not.
I just want to know.
Yes.
What you see? What implies? You see the application of 27A.
27A.
Like you said, if it talks about financing, harboring.
Yes.
What exactly constitute
Yes.
financing and what exactly constitute harboring?
Yes.
Like you said, maybe there are. You see, if it is one isolated transaction, whether that would fall under the mischief of 27A, or it has to be over a period of time, and that link has to be there. The accused is known to
Lordship, as I submitted, had we been arguing on 482 or 22, 482 before this High Court or 227, all these arguments are very valid, Your Lordship. Very, very valid argument. Then court would have lived the veil and would have further in what is the meaning of financial implied directly, what is the meaning of harbor person activity or not. Court would have gone into those aspects. But right now, Your Lordship, we are not into that. The prayer is very, very simplistic prayer that 2 witnesses have been examined, the rest is yet to be examined. And it's a case of bail simpliciter.
That's what I said earlier.
Yes. So in the case of bail simpliciter, I'm sorry, Your Lordship, can we really forward an argument on 482?
Well, he has not been able to. That's all. See, he has not been able to present. You see, any concrete argument.
Yes.
As far as nor is it there. You see, you have not made any argument, any arguments as far as why Section 27A should not be taken into account.
Yes. Yes.
You have not done. That's what I've said earlier.
Yes.
Your bail application is silent on that. But because of your insistence, again I'm repeating myself, that the onus is on the court to go through the materials on the court and find out, you see, as to whether you see the insertion of 27A is justified or not. So because of that, we are going through this exercise.
Absolutely not.
That is, you see, it's imperative that the court would render justice.
Yes.
So to that extent, I would concede that yes, but the fact remains that you have to back up your case.
But Lordship, there is no foundation for his argument in his bail application. First and foremost, Your Lordship, had the foundational facts been there, then maybe we could have. There's nothing is there in the prayer. No, he's asking for bail simpliciter. And other aspects of the matter, Lordship, you would be transgressing into an area where the only 2 witnesses have been examined. If I may submit, only limited argument he could have argued is the 2 witnesses have been examined. The rest 8 has to be done it. Now, supposing he brings the list of other 8 witnesses, then Lordship there's a settled law that court will not critically evaluate in a post-charge sheet matter on a bail matter by evaluating the evidence. At the best, it can do is prima facie. And prima facie would not be shifting the evidence.
No.
As you know, what is then in chief or what is then the cross? Court will not entertain that.
That is why you see the charge sheet was perused
Yes.
to find out as to what is the the finding of the IO as far as
27.
27 is concerned.
That is why. Otherwise, if it comes in evidence that yes, it is proved through cogent evidence that it is present, that is a different matter altogether.
Yes.
We are not concerned with that.
No, Lordship. Now, assuming a situation, as I said, assuming a situation now, trial goes on. In the middle of a trial, prosecution finds is a shaky evidence of 27A. Prosecution can easily find an application at 216 and alter the charges.
That is alteration and deletion is
no. I'm saying in the middle of a trial. That is not that is not the issue. Even while sentencing. But at this stage, prima facie, there's an element, whether it's a financial activities or inactivity, harboring person engaged in the activity, these are matter of evidence. If there is no evidence forthcoming, and in chief or cross. So we are not into that stage, Lordship. I got very limited response that 2 witnesses, 7, that is this limited argument that he can forward so far this case is concerned. 2 witnesses and 8 has to be examined.
What was the amount of seizure here?
3.67 gram. 3.67 gram from her possession.
So prima facie, Lordship. Prima facie, the rigor of 37 says once you commit an offence, while on bail was cancelled and High Court has upheld. That has not been set aside.
Not in this case.
No, in other case, we are going into the prima facie part of it.
That one I will come later.
Yes, prima facie part of it. So that is to the rigor of 37A. The court has to see there is a violation and that has been upheld by the court. So we have got additional argument to support prima facie here.
Only if this court holds that section 37 is applicable here.
Yes.
If not,
yes, absolutely.
And again, we come back to the same thing. We're just going round and round here.
Absolutely, Lordship. That's what I said. Had it been 482-227, Lordship, we would have argued at length maybe. And then Lordship had granted him time to at least bring a citation. He said that there's nothing bars the court from it, Lordship. We are not that we are aware of it. There's nothing bar.
Even see, Mr. Khan, even prima facie, I don't find any element of 27A here. How long has she been here in
10 months.
10 months.
More than 10 months, yes.
10 months. As far as this case is concerned.
Yes.
Lordship, the bail 28 March 2025. The cancellation was done. Bail was granted.
Not in this case.
No,
in this case.
Not in this case. The other case.
I will come later.
No, Lordship, we'll see, Lordship. There are three situations here. One case, she was acquitted. Another case, trial is on. Then during the pendency of this case,
this is third case.
MP stringent law was applied. No, that was not quashed. Lordship, we kindly make a distinction between not quashed and running its course. It ran its course of 3 months. That means the detention period was over. In other words, the detention was not challenged, not set aside, and completed its course.
But under such circumstances, can it be extended or?
No, I'm not into extension. I'm saying that it ran its own course.
No, it has run its own course, no doubt.
Own course. That means found
objective fulfilled.
Objective fulfilled. In other words, that was not set aside. So prima facie, if you argue on prima facie,
what you mean to say is that the implication would still be
absolutely present. Implication here ran its course. For example, like somebody is convicted for 6 months, Lordship. After 6 months, but the implication will be that it was convicted. It is a different thing whether the prosecution went to the High Court and enhanced the punishment or not. In this case, it is a different thing whether they came to the court or set aside. It ran its own course means. So, Lordship, the element of prima facie, acquittal, MPDA detention order ran its own course. High Court setting aside on prima facie, and then we have an issue. And Lordship, if you just come, I'm just grateful to my friend, Lordship, we just try to assess the court. Section 213 of the NDPS Act. Sorry? IPC. Can we rely on it? Oh, BNS says, Lordship. BNS 2023, Section 2, Subclause 13.
Definition.
Definition of harbour. Okay. IPC is video. Just to assess the code, Your Lordship, maybe. Of course, it doesn't basically answer the query, but it has got a very wide meaning, Your Lordship.
2.
Section 2, Subclause 13. BNS 2023.
Subclause.
Section 2.
Yes, section 2.
Subclause 13, Lordship. 213.
13.
1-3.
Where is 1 3? Oh, sorry.
BNS.
No, BNSS.
BNS. Bharatiya Nyaya Samiti. It will be Evidence Act. IPC. We still have problem of nomenclature. Assisting our case would be, Lordship, the assisting of a person by any means very, very extensive, whether of same kind as those enumerated in this clause or not, to evade apprehension. Assisting a person by any means, including, it's very, very vague. Of course, Lordship, I will not be
Not applicable in this case.
Absolutely, I submit to be
As far as
saying
the
not
Noor
applicable.
Jahan is concerned, not applicable. You cannot say that, there is no shred of evidence in this regard.
But assisting any person, Your Lordship.
Any person, yes, where is that person?
No, Lordship, assisting any person by any means. No, by any means, she was assisting the main accused by keeping the container.
Where is that main accused?
Ayesha Khatun, the main accused is here.
She will main accused and she will harbor herself.
See, Mr. Khan, we should be fair.
Lordship, as I submitted, Lordship,
Just for this.
Lordship, as I submitted, had it been 482, 227 years, I'm not into 482, Your Lordship.
And he's not pressing for that.
Absolutely.
He will fight it out in the trial.
Yes.
So that's a different thing altogether.
Right now, we are into only the rigor of, Your Lordship, 37. We are only into the rigor of 37, 27A. And Your Lordship, I said acquittal, 2 cases pending, 1 illegal detention matter ran its course. It was convicted, technically speaking. Once it runs its course, she was convicted. We will not use the term convictions in MPDA, but it ran its course of completing the sentence. So there's almost like she is guilty in one case she is acquitted, in other she is trial. This is the 4th case. We have got 4 cases against this accused. And the rigor of 37 clearly says even if you are granted bail, adding to that, she was granted bail, violation of terms conditions, she avoided, and High Court upheld it. So prima facie cases, Lordship, is fully fortified.
There are 4 cases pending now.
No, my lord.
2 cases.
2 cases. For both the cases, I have filed bail. Only 2 cases.
But in the other one, 37 is there.
No, nobody, in none of the case 37 is there.
Okay, good.
Only these 2 cases pending. 1 case was already acquitted.
So of submission is, Lordship, he is facing trial. There are 2 witnesses.
But that's you see, like I said, there are other considerations apart from all these. After everything has been said and done.
Absolutely.
Bail, as far as bail consideration, firstly, this court will emphasize on the fact that it is the discretion of the court.
Yes. Discretion of the
Guidelines are there, parameters are there. It has been enumerated from time to time.
Lordship.
And one of those parameters or guidelines is the severity of the offence.
Absolutely.
It may not be present here.
Yes.
Severity of the offence, past conduct.
But like, again, if you recollect what I was saying the other day, the antecedent,
Yes,
that has to be looked into.
absolutely.
If the person is found to be involved in 1, 2, 3, 4, 5 cases of the same kind,
Yes, ma'am.
definitely, there's no question of bail.
In fact, that was the only. That was the only. Lordship will
That is one of the factors.
Lordship will kindly
That is one of the factors.
recollect. I was emphasizing only in that part, except because he opened up different arguments on 27A. And I said like that is the only requirement so far this bail application is concerned.
Past criminal antecedent, that has to be. I also agree, my lord. But if the person is otherwise entitled, that also can be for the same time.
Oh, he may be
From the
entitled.
facts and circumstances.
He or she may be entitled, no doubt. But then the point remains:
Yes.
if you have been convicted,
Not convicted.
not convicted.
Not convicted in any case. Acquittal.
Oh, okay. Or you've been acquitted.
Acquitted. Yeah.
Then, but then
Two matters trials are on.
These two cases are going on.
Trials are on.
These
two
two
matters.
cases are going on. One, I have been acquitted because there was
And
no
one in
evidence.
illegal detention, she
No,
ran
that
out
is
the course.
illegal. Because of this pendency of the cases, that preventive detention was invoked. Cannot be counted as separate case.
That ran out of its course, Your Lordship. Again, that would be a subject matter of academic discussion. What happens when a Lordship has done so many MPDA matters? Midway, court steps in and satisfies everything. That is a different issue. But in this case, there was no challenge, and 3 months was the minimum period that ran its course. So I leave it to the court to infer what could be a situation.
I think I'll not be able to pass order in court today because we have other matters also. And in no time I have to sit for DB. So this is, I'll reserve my order here.
And that
The other case?
another
What is
case is 36. In this case, my lord, bail was granted. Here, this is intermediate quantity. She was arrested in the year 31st May 2023, in the year 23, and she was granted bail. So, bail was granted on condition that she will not be involved in any kind of similar cases. But this Molai PS case, this case was registered in 2024, and accordingly, her bail was cancelled on that ground, violation of the condition that she is involved in other cases. So she was again arrested. She was kept in custody. So my lord, in this case is going on since 2023.
So in this case, earlier she was
Bail was granted.
granted bail.
Yes.
Then subsequently,
It was cancelled because I have violated the condition on the registration of the another case. So bail was cancelled. Thereafter, my lord, I challenged that legality of the order before the Honorable High Court. But the High Court has said that the trial court was justified in cancelling the bail because prima facie this case has been registered. So my contention before the Honorable Court was that only that cannot be a factor. But prima facie it was there, the case was there, so it was cancelled. So after bail is cancelled, my lord, there cannot be any ground for, I cannot file fresh. Fresh bail application was filed on the ground that she has been in custody for so long, and in this case, four witnesses have already been examined.
how many altogether?
Out of 10. Out of 10. Out of 10, my lord, I think 4 witnesses has been examined.
So what are your grounds in this case?
This ground is that, my lord, that she has been in custody for long time.
How long?
And 23, again she was on bail for some time, so more than a year.
No, after the last time she was
Arrested on 20.
arrested.
Yes. So 10 months plus 1 year, almost 1 year she was in custody. And section 37 is not attracted since it is intermediate quantity. Out of 10 witnesses, 4 witnesses has been examined. So further detention of the accused in the instant case is not required. It will not serve any purpose. And my ground is that if she will be enlarged on bail, then she will be in proper position to defend her case effectively. That is the only limited ground. Only on 4 grounds, that 4 witnesses has been examined, bail was already there, it was cancelled, and she will be released. Her custody is not required further, and if she will be released, she can defend her case properly. That is the only.
Mr. Khan, see, fact remains there are 2 applications filed by the same person involved in similar offence. As far as, again, say, as far as the consideration for bail is concerned, you have any authority to help this court as to the issue of antecedent, the issue of being involved in multiple cases of the same kind, where even if I'm saying this, even if eligible in one case, the court can still discard the prayer or not grant bail because of the fact that such a person, maybe she in this case, is involved in another case. You have any decision on?
Lordship will try to give it right now. I have, Your Lordship, some judgment, but Your Lordship, only difficulty in giving a citation is this: the peculiar fact of this case is very, very peculiar. So maybe the precedent will not be binding. That is the only problem.
No,
I have to admit, Your Lordship, because the first case is 27A with 37. In the second case, Your Lordship, in the second case, he is not argued anything. What is the change circumstances? Number 1. Kindly appreciate, Lordship. Only thing is saying the 4 witnesses being examined out of 10, and then he is coming before the court on a cancellation of the bail upheld by High Court. The first prerequisite is he has to argue on changed circumstances. Only ground he's saying is a delay. Now, 10 out of 4, cannot be ground for delay.
No.
10 out of 4 cannot be ground for delay. Then he has to also argue where this 4 witnesses has clearly shown that the prosecution witnesses are shaken and it's not a prima facie case.
That one I can produce.
Limited argument for him will be on a ground of delay would be it has been an inordinate delay, not normal delay. Our common sense approach would be 10 out of 4 will not be a delay. Number 2, he is not argued this. He is not brought any deposition that this 4 deposition clearly shakes the prosecution witness and is in favor of accused. So there is nothing before the court to consider whether the second bail application should be considered. So in this view of the peculiar facts, Your Lordship, I don't think so. This is a case for bail.
Fresh circumstances has to be cited.
No,
Absolutely.
circumstances, because
Only-
bail was cancelled
only-
1 year since that. For 10 months he has been there. Bail was cancelled 10 months back. The only ground is that 10 witnesses out of 4 has been examined, and after cancellation of bail she has been for 10 months after cancellation. So further custody at this stage is not required, and further the thing is that she cannot be kept behind the bar for indefinite period of time till conclusion of trial. That is the only ground, and because I cannot go again with the evidence.
So I've heard the parties
Obliged.
pass this orders.
Item number 4.
This is the old matter and the records has already been received, my lord. So anytime we are ready with the hearing, my lord. It will take some time. So I'm praying if my lord allows that we can do the hearing after 1 week or 2 weeks now. Records are there, my lord. I can rely on the record at the time of hearing from the Deputy Commissioner's office. It has been collected and received.
Records have come. All.
See, since 16 July, records have already been
Well,
produced.
Both from the revenue
You
board and from
yes,
the deputy commissioner.
you have on that day you have sought for time to go through the records. Now we are almost 1 month.
I have gone through the records. I have already written it.
Oh, yeah.
after seeing also.
Then?
So I'm saying that we can do the hearing anytime after 2 weeks.
Why not? Why not now?
It will take some time for.
It will take some time. Everything takes time.
Yes, my lord.
So if we don't start now, when do we start?
Next week, my lord, we'll do it. Matter is listed on the top of the list, my lord.
Even if you go over the top, also it makes no difference.
If it is on a fresh, on the top of the list.
Mr. Paul, you are ready?
well, I can start. I'd already placed the facts of this case.
Yes. If I recall, it is only on that issue of
Limited
jurisdiction.
issue of jurisdiction.
So why would you resist?
As a matter of fact, I had made a prayer, your lordship should recollect. This matter can be remanded back to the deputy commissioner by setting aside both these two orders with a specific direction that on these issues pass a speaking order.
But the fact
So-
is
so-
that the difficulty is that, my lord, the complainant has already expired. To start from that point.
No,
it
no.
will be-
Yes, my lords have
that is
already
what-
granted liberty.
Complainant expired.
Expired. my lord.
This is that matter where my lords,
yes,
your
yes,
lordship.
yes.
Now the fact
Respondent number 1.
Now the fact remains is that the matter is that once an matter is brought to the knowledge of the government, can the government keep a blind eye over
No,
that?
no, I'm
my
not
lord?
saying
So-
that, my lords. I'm
so-
saying that let the proceedings continue. As a
so
matter of fact, while my lords had disposed of that matter,
What the deputy commissioner wanted was that let it be confirmed or cancelled by the secretary to the revenue department, my lord. Against that, they have gone to the revenue board, and revenue board on some other ground, saying that on the ground of maintenance and locus, has rejected their petition, my lord. So, being aggrieved by that application, my lord, they had come for revision before this High Court. And what I am saying is that the deputy commissioner was well within his right to send it for confirmation or cancellation of whatever a tentative mind was formed by the deputy commissioner on receipt of the complaint, my lord.
Before the Board of Revenue, have you raised this issue of
Yes, yes.
jurisdiction?
yes,
Was it decided?
no,
Only your locus was decided.
my lords, they dismissed my entire appeal on locus.
On locus.
But not whether the deputy commissioner was competent or not to.
No, lordship.
No, my lord.
Which is why I submit, my lords, both these two orders have to go. And the matter has to go back before the first court, where, my lords, the matter can be decided. Especially in view of the judgment on order dated 21/10/2024 that's been passed by my lords in the miscellaneous case. That's trying to be fair, my lords. Because in that, the last paragraph, if I may just place, my lords, para 25, I'll just read, my lords. In view of the above observation, this court finds that the applicant has not been able to make out a case either for impleadment as party respondent in the related proceedings or for vacation of the order dated so and so. The application is therefore dismissed as devoid of merits. However, my lords, in the earlier paragraph, my lords have given a little handle to them that they can move before the original forum, my lords, for
For the substitution thing.
I am trying to be fair. Because somebody should not be, my lords, denied of any rights. If something has fallen from this honorable court, my lords, it has to go back before that forum. If they want to bring something, well, they can bring it on record.
But what I am saying
because
is,
you
my lord, there is already a finding by the office of the deputy commissioner, my lord, and there is also a finding by the revenue
if
board.
that finding was made,
After taking all the evidence
if the
and
finding
documents, my lord.
was made on a wrong jurisdiction, then it's no finding at all.
Everything goes.
No, the deputy commissioner's jurisdiction was never challenged.
It is challenged. It is the order itself says.
And that is why, my lord, the deputy commissioner did not take the matter on his own. They has referred the matter to the secretary revenue board, secretary revenue department.
Secretary revenue is also incompetent, my lords. I can place the entire law.
But this was the argument which was placed.
No,
before
no,
the
it's
deputy
not the secretary,
commissioner,
my lords, it's
and
the-
which led to the.
What my learned friend is missing out, my lords, what we had pointed out is the two aspects to the matter. That if it is a complaint, my lords, it has to be dealt by the commissioner. The Meghalaya interpretation of statutes, my lords, is deputy commissioner is not competent to take up that matter. It basically becomes a question of quorum non judice. That's one. Second aspect of the matter is, my lords, it's essentially a title dispute. And the law is well settled, my lords. We place the law saying that in these kind of matters, then the only competent forum is a civil court, which has to then adjudicate on title. So these two issues were never decided. What the deputy commissioner, as a matter of fact, it's absolutely preposterous what is written. And if I can remember correctly, it said, as per custom in Meghalaya, deputy commissioner is so and so. Something related to that extent. I can just point out, Melissa. I said, I'll just point out the order passed by the deputy commissioner. Just give me the page. Page 50. If my lords kindly have page 51, this is the order dated 31/5/2023. My lords have it.
Page
51. My lords have it.
Yes.
May I just read, my lords? After going through the submission documents placed by the parties and Rule 26 of the Settlement Rules on Section 315 of the Interpretation of General Clauses Act, so and so, this court is of the opinion that it is a well settled principle of law in Meghalaya that the Commissioner and Secretary Revenue Department Governor shall have the power to confirm or cancel all settlements in its division, which may consist of a number of districts, and the Deputy Commissioner of the district, after following the due process, refers the matter either for confirmation or settlement or for cancellation of the settlements done in his district to the Commissioner Secretary Revenue of the Department of Government of Meghalaya. This being the settled principle of law, I am of the opinion that the plea of the OP is not maintainable, hence cannot be considered. Moreover, OP so-and-so has not been able to prove his identity in relation to Radha Binod Chaudhary and asked by the court. Therefore, the prayer of the petitioner is hereby allowed. The patta settlement of so-and-so is presently in the name of so-and-so is hereby referred to the authorities for cancellation of the same. It is effectively deciding this matter. When you are not authorized, Millers, Section, as a matter of fact, we had pointed out, Millers, Rule 26 and Section 315 of the General Clauses Act, Meghalaya General Clauses Act, Millers, is very specific. Who's the authority who's competent? And Millers, in the given facts and circumstances of the case, we had also pointed out that if it is a title dispute, matter essentially has to be referred before a civil court. Civil court will then pass a decree, and whoever, Millers, gets a decree in their favor will be the person competent. So these are issues, Millers. If I've raised an objection regarding jurisdiction, you have to deal with it.
But those are these, specific issues which you have,
Agitated before
which
the
you have, taken
Revenue
the-
Board also.
yeah, the Revenue Board.
Revenue Board, my lords, after discussing everything, says that I don't have locus to prefer an appeal. The difficulty is, my lords, that these authorities, and why the law is crystallized, as your lordships are well aware, my lords, revenue authorities are usually manned by people who are not probably versed in law. Which is why, my lords, your lordships have then, my lords, crystallized the law. Rajform Rajendar, my lords, I can place the series of authorities, including very recent judgment of the Honorable Supreme Court as well as on the same issue, that when there is this question of dispute, my lords, which has to be proven by leading evidence, it is only and only a competent civil court will then decide the matter. Whoever is aggrieved, my lords, has to go over a civil court, seek appropriate relief of declaration and injunction, my lords, and on that basis, something will. In this case, it will be a mandatory injunction, not a prohibitory
But
injunction.
what is the purpose of having these authorities in place then?
My lords, that is only for the purposes of revenue. Rajendra Kumar, my lords, if your lordship see that
Not for deciding.
not for decision on title. I'll take your lordships. I can place the entire authorities. As a matter of fact, when the matter was heard before the Revenue Board also, my lords, we've placed Guwahati High Court, a full bench of the Guwahati High Court had the occasion to deal with these very rules. And there also, my lords, they have taken a view that it is not for the revenue authorities to decide on questions of title. It is for a competent civil court only. That can be done only by leading evidence. But here, my lords, the prima facie issue was that whether you are...
Have you raised that as one of your grounds?
Yes, yes. All these were there, my lords. I'll take your lordships to my memorandum of appeal. I'll take my lords...
Then, but Mr. Sengupta is not ready.
Then my lords may fix a date for hearing. I'll also be prepared with the law so I can place the entire law.
Only thing is that, my lord, what had happened is that when the complaint was received, my lord,
Let's not go into that. Otherwise, if you are prepared for full-fledged hearing,
Because we are unnecessarily impeding on the time of this honorable court without even arguing the matter. No point. My lords may fix a date. On that date, my lords, let it be understood that the matter will be heard.
it has to.
My lords.
Otherwise, you suggest a date.
Let it be on the 19th, my lord.
Tuesday
Okay.
or Monday. Well, 19th was Tuesday.
Mr. S. Gupta, learned additional senior G has submitted that he may be accommodated in this matter for the day since he is not prepared to be heard today. Mr. K. Paul and senior counsel appears for the petitioner as prayed for and agreed to by the parties. Ashokatu pray aloud as agreed to by the parties. This is matter for the hearing on
19th of August. I'll reply.
Item number 5.
Lordship, there's an order passed by your Lordship on 6/9/24, Lordship.
20.
6/9/2024.
Yes.
Lordship, submission was made by the learned Advocate General saying that there's an other issue pending before the division bench, Lordship.
Yes, Mr. Shulai.
May it pleases your lordship. Lordship, in my humble and respectful submission, your lordship, that issue before the division bench is that Himamolong case, that is a customary toolkit, but this is the non-tribal toolkit, your lordship. So it has no, that case, it has no bearing or relevant with the case in hand, your lordship.
But this submission was made from your side.
Lordship, it
It may not have been made by you, but by
lordship, yes,
one of
but
your
it's
colleague.
because your lordship, that decision of Himamolong, your lordship is well aware that is the decision rendered by this honorable court, your lordship. That is on regard to the power of the traditional chief to collect customary toll, but this is not the customary toll, your lordship. Lordship, since that
Still pending before the
that
division
also,
bench.
that submission has been made, your lordship, then
No, submission may have been made. A clarification can come.
Lordship.
It doesn't mean that it's a hard and fast rule.
lordship,
It's not a judgment per se.
lordship, because lordship, that as I have submitted, your lordship, that matter before the division bench, that is a customary toolkit which rendered by this honorable court, your lordship. Lordship is well aware of that.
The court will make a reference to this order and say that in the light of what has been submitted by Learned AAG, this has got no connection with the other case. Then
Lordship, though we are not party to those proceedings, Lordship, if your Lordship may kindly grant us some time, we'll just go through, your Lordship. If there's, we can just verify. We're not party to those proceedings, Lordship.
Lordship, yes, they
We
can
can
do that.
verify the judgment per se. Lordship.
okay. As prayed for by Mr. M.L. Pure counsel for the petitioner. Matters adjourned. This is the same after 1 week.
1 week, Lordship.
Let it be 2 weeks, your lordship. Let it be 2 weeks.
2 weeks.
Apply, your lordship.
Item number 6.
Lordship, on the last occasion, this matter was in fact almost concluded by the
No, Lordship.
respondent counsel. And,
Lordship, if I may submit, Lordship, Lordship, the learned senior counsel is on legs. Some difficulty, Lordship. If I'm praying for Friday, Lordship, this Friday,
Lordship.
because what happened, Lordship, every Tuesday and Thursday there's a division bench, in the coordinate bench. So that some difficulties in that. So I'm just praying on Friday. Lordship, the petitioner here has urged 3 grounds, Lordship. Now, so far as we have only argued on 1 ground, Lordship. So
Hearing is not concluded.
not
It will
concluded,
continue.
Lordship. Lordship.
Lordship, this is a parhad matter, and Admittedly, after division once, we can resume, Your Lordship. I mean, later in the afternoon, Your Lordship.
Subject to your lordship's convenience.
Depends on the parties.
Yes, I wanted to conclude this, Your Lordship.
Lordship. I'm praying for Friday, your lordship, but if your lordship is
After DB1, there will be no other matters.
Friday, yeah.
No, Friday.
it can come on the bottom of at the top of the list also, your lordship, because it's a part heard matter.
We'll take it up on Friday.
That will be top of the list, Your Lordship.
It's a part heard matter, top of the list.
It will come as it will come in the supplementary list. So
Lordship.
definitely. As paid for by the parties, list this matter on Friday for the hearing.
Much.
Hello, Lordship.
Second call from supplementary list, item number 1.
My Lord, on the previous date, my Lord had some apprehension with regards to this matter in view of the judgment, my Lord. My Lord, I've had the opportunity of going through the judgment in depth, my Lord. My Lord, the actual substance of the judgment and the ratio which it has laid down, my Lord, to understand, my Lord, we will have to go back to the judgment in the case of Antule, because the ratio as laid down by Antule has been absolutely followed, my Lord, in P. Ramachandra Rao. So, my Lord, I will be submitting a compilation of 3 judgments. One is the judgment which my Lord, based on which my Lord has taken the view that the petition might not be maintainable. My Lord, the second judgment is the judgment, my Lord, on which the ratio of which has been followed. Exactly. And the third judgment is, my Lord, which succeeds both the judgments, where P. Ramachandra Rao has been interpreted by the apex court, and based on P. Ramachandra Rao and Antule's judgment, they have quashed the proceeding, my Lord, for delay. So, my Lord, when we read P. Ramachandra Rao in depth, my Lord, the facts of that case have got nothing to pertain with the facts on which we stand, my Lord. My Lord, in P. Ramachandra Rao, the core issue was that, my Lord, there were 2 judgments passed in a case of common cause 1 and common cause 2. Now, my Lord, in the case of my Lord, I am giving an overview. I'll take, my Lord, to the relevant portions in the judgment. My Lord, in the case of common cause, the apex court then had framed a time limit, my Lord. They had classified the offences, those punishable up to 3 years, those punishable less than 3 years, ones non-cognizable, and the ones where it's a summon case trial, my Lord. Therein, they had fixed certain time frames. Now, my Lord, based on those time frames, certain issues had cropped up. So, my Lord, when those issues cropped up and the matter reached the apex court again, my Lord, that is the time when a constitutional bench was referred to, a constitutional bench consisting of 7 honorable Punish judges, my Lord, which brought us to the judgment in Ramachandra Rao. Now, my Lord, in Ramachandra Rao, my Lord, if we may begin, my Lord, page 588 of my Lord, I'll take some time on it. If my Lord will have to go for the division bench. Lord, can we resume after?
Not today.
Not today. Lord, can I take 5 minutes in that case just to give an overview, and then we can continue maybe tomorrow? My Lord is of the opinion. My Lord, I'll not go far, my Lord. I'll only show 2 relevant portions here.
Page?
My Lord, we can come to page 587, my Lord. It's page 10 of the compilation, internal page 10, my Lord.
Yes.
May I, my Lord? My Lord, from F. The mental agony, expense and strain, if I have, my Lord. May I, my Lord?
Yes.
The mental agony, expense and strain which a person proceeds against in criminal law has to undergo, and which, coupled with delay, may result in impairing the capability or ability of the accused to defend himself, have persuaded the constitutional courts of the country in holding the right to speedy trial a manifestation of fair, just and reasonable procedure enshrined in Article 21. Speedy trial again would encompass within its sweep all its stages, including investigation, inquiry, trial, appeal, revision and retrial. In short, everything commencing with an accusation and expiring with the final verdict. The two being respectively the terminus acque and terminus ad quem of the journey which an accused must necessarily undertake once faced with an implication. The constitutional philosophy propounded as right to speedy trial has, though grown in age by almost 2.5 decades, the goal sought to be achieved is yet a far off peak. Myriad fact situations bearing testimony to denial of such fundamental right to the accused persons on account of failure on the part of prosecution agencies and the executive to act, and their turning an almost blind eye at securing expeditious and speedy trial so as to satisfy the mandate of Article 21 of the Constitution, have persuaded this court in devising solutions which go to the extent of almost enacting by judicial verdict bars of limitation beyond which the trial shall not proceed and the arm of law shall not lose its hold, my lord. My lord, page 590, internal page 13, my lord. Again at entry F. If I have, my lord?
Yes.
My lord, serial number 8, internal page 13.
Yes.
Serial number 8. Now, my lord, here again the judgments as was pronounced in the Constitutional Bench of Maneka Gandhi versus Union of India, my lord, which has established that Article 21, which envisages life and liberty, my lord, has got wide-reaching effects and has got a very broad spectrum. Now, my lord, from there it is quoted, no procedure which does not ensure a reasonable quick trial can be regarded as reasonable, fair or just, and it would fall foul of Article 21. There can therefore be no doubt that speedy trial, and by speedy trial we mean reasonable expeditious trial, is an integral and essential part of the fundamental right to life and liberty enshrined in Article 21. My lord, we are on the, there is no denial to a fact that Article 21, which covers my right to life and liberty, also ensures that the trial which I am facing has to be speedy and expeditious, my lord. My lord, page 591, my lord. The material in this judgment, my lord, S.R. Rao starts from here. This was the prelude to it. My lord, serial number 9. If I may, my lord.
Yes.
The Constitution Bench in A.R. Antule's case heard elaborate arguments. The court in its pronouncement formulated certain propositions, 11 in number, meant to serve as guidelines. It is not necessary for our purpose to reproduce all those propositions. Suffice it to state that in the opinion of the Constitution Bench, 1. Fair, just and reasonable procedure implicit in Article 21 of the Constitution creates a right in the accused to be tried speedily. 2. Right to speedy trial flowing from Article 21 encompasses all the stages, namely the stage of investigation, trial, inquiry, trial, appeal, revision and retrial. 3. Who is responsible for the delay and what factors have contributed towards delay are relevant factors. Attendant circumstances including nature of the offence, number of accused and witnesses, the workload of the court concerned, prevailing local conditions and so on. What is called the systematic delay must be kept in view. Each and every delay does not necessarily prejudice the accused, as some delays indeed work to his advantage. Guidelines 8, 9, 10 and 11 are relevant for our purpose and hence are extracted and reproduced herein below. 8. Ultimately, the court has to balance the weight and several relevant factors, balancing test or balancing process, and determine in each case whether the right to speedy trial has been denied in a given case. 9. Ordinarily speaking, where the court comes to the conclusion that the right to speedy trial of an accused has been infringed, the charges or the conviction, as the case may be, shall be quashed. My lord, these are the guidelines flowing from Antule, and as we go ahead, we will see that this has been upheld by this particular judgment, my lord. My lord. But that is, ordinarily speaking, where the court comes to the conclusion that right to speedy trial of an accused has been infringed, the charges or the conviction, as the case may be, shall be quashed. But this is not the only course open. The nature of offence and other circumstances in a given case may be such that quashing of proceedings may not be in the interest of justice. In such a case, it is open to the court to make such other appropriate orders, including an order to conclude the trial within a fixed time where the trial is not concluded, or reducing the sentence where the trial is concluded, as may be deemed just and equitable in the circumstances of the case. It is neither advisable nor practicable to fix any time limit for trial of offences. Any such rule is bound to be a qualified one. Such rule cannot be evolved merely to shift the burden of proving justification on the shoulders of the prosecution. In every case of complaint of denial of right to speedy trial, it is primarily for the prosecution to justify and explain the delay. My lord, page 598. My lord, internal page 21, my lord. May I continue, my lord? It is all necessary to have limitation bars terminating trials and proceedings. Is there no effective mechanism available for achieving the same end? The Criminal Procedure Code as it stands incorporates a few provisions to which resort can be had for protecting the interest of the accused and saving him from unreasonable proximity or laxity at the trial amounting to oppression. Section 309 dealing with the power to postpone or adjourn proceeding, otherwise generally for every inquiry or trial being proceeded with as expeditiously as possible, and in particular when the examination of witness has once begun, the same to be continued from day to day until all the witnesses in the attendance have been examined, unless the court finds the adjournment for the same beyond the following day to be necessary for reasons to be recorded. Explanation 2 to section 309 confers powers on the court to impose costs to be paid by prosecution or the accused in appropriate cases, and putting the parties on terms while granting an adjournment or postponing of the proceedings. The power to impose cost is rarely exercised by the courts. My lord, 5 lines below, the summon trial is not applicable.
These are all, restatement of the law.
My lord.
Whatever has crystallized through the different pronouncement.
My lord.
Is there. The subject, you see, the subject of discussion is on delay, on trial, on speedy trial.
My lord.
So,
my lord, if we can come to para 28.
Para 28.
Internal page 25. This is of importance on this judgment, my lord. What does the judgment of my lord R.P. Ramachandra Rao states? May I, my lord?
Yes.
This is where they are giving the dictum and they are concluding it. My lord. My lord, this was a dissenting judgment. However, in the dissent also, it is a slight dissent where the dissenting honorable judge also agrees to almost everything that they have laid down. What concerns us is, my lord, Antule has also, in the descending note also, the honorable lordship there has agreed that yes, Antule stands ground. And we'll revert to Antule, my lord, para 28. The other reason why the bar of limitation enacted in Common Cause 1, Common Cause 2 and Rajdiyo Sharma 1 and Rajdiyo Sharma 2 cannot be sustained is that these decisions, though 2 or 3 judge bench decisions, run counter to that extent to the dictum of the Constitution bench in A.R. Antule's case. So, my lord, this judgment, like I opened my submissions, it deals with those 4 cases where an actual time limit was prescribed in the judgment. And the court says that they cannot be sustained, not because of the judgment in my lord P. Ramachandra Rao, but because it runs in contravention to the law laid down in Antule's matter, my lord, which was again a constitutional bench judgment. And therefore cannot be said to be good law to the extent that they are in breach of the doctrine of precedents. The well-settled principle of precedents, which has crystallized into a rule of law, is that a bench of lesser strength is bound by the view expressed by a bench of the larger strength and cannot take a view in departure or in conflict therefrom. We have in the earlier part of this judgment extracted and reproduced pages from A.R. Antule's case. My lord, they'll say the same thing here, that the law on Antule stands ground, and thus this judgment endorses the law as laid down in A.R. Antule's matter, but uprooted the law as was supposedly being laid down in Common Cause 1, 2 and Shioraj, my lord, wherein they had given a definitive time limit. Now, my lord, continuing page, my lord, para 29. May I, my lord?
So this is the verdict.
This is the verdict. For all the foregoing reasons, we are of the opinion that in Common Cause case, as modified in Common Cause case 2 and Rajdev Sharma 1 and 2, the court could not have prescribed periods of limitation beyond which the trial of a criminal case or a criminal proceeding cannot continue and must mandatorily be closed following by an order acquitting or discharging the accused. In conclusion, we hold 1. The dictum in A.R. Antule case is correct and still holds the field. 2. The propositions emerging from Article 21 of the Constitution and expounding the right to speedy trial laid down as guidelines in A.R. Antule's case adequately take care of right to speedy trial. We uphold and reaffirm the said propositions. 3. The guidelines laid down in A.R. Antule's case are not exhaustive but only illustrative. They are not intended to operate as hard and fast rules or to be applied like a straitjacket formula. Their applicability would depend on the fact situation of each case. It is difficult to foresee all situations and no generalization can be made. My lord, my understanding, my lord, from the judgment comes that my petition to file for quashing, my lord, because of a delay in my trial, which has infringed my fundamental rights as enshrined under Article 21, is maintainable, my lord. Once we see the factual scenario, like the law has been laid down, the law says, my lord, that it is for the prosecution now to come and show what are the reasons of delay. Now, the law also says, my lord, I have to admit, I have to submit very fairly on it. My lord, if the prosecution shows that those delays are the delays which are acceptable to the conscience of the court, my lord, then they are delays which are justified. Else, my lord, it has to be accepted that my fundamental rights have been infringed. Now, when once, my lord, it has been demonstrated that my fundamental rights have been infringed, then, my lord, either the proceedings have to be quashed, because quashing of the proceedings as laid down in A.R. Antule has been upheld by the subsequent judgment of a larger constitution bench, my lord. A.R. Antule was a 5-judge bench, my lord. P. Ramachandra Rao was a 7-judge bench, my lord. That quashing is an option which can be exercised. If the court is of the view that no quashing cannot be done, my lord, then the other alternate options which emanate would amount to directing the court, my lord, for a day-to-day trial up to the wisdom, my lord, as it would befall from my lord, or maybe a time frame fixed as to the court. But, my lord, my petition is maintainable. Now, my lord, I have annexed certain orders. My lord, I can take, my lord, through A.R. Antule, but A.R. Antule has been summed up very categorically over here. My lord, one judgment, my lord, I'll just sum up the argument on this initial point of law, my lord. My lord, page number, internal page 86, Pankaj Kumar versus State of Maharashtra, 2008, 16 SCC 117, my lord.
Yes. Para?
My lord, page 89. My lord comes to page 89. My lord, the case of Listis as have been cited. My lord, page 89.
Page 89, yes.
My lord, entry 4. My lord will find 2002 4 SCC 578 P. Ramachandra Rao. The citations relied upon, my lord, in this judgment.
Yes.
My lord will also find, my lord, at entry 12, 1992 1 SCC 225, Abdul Rahman Antule, A.R. Antule, my lord. And in the middle, my lord, entry number 6, 7, 8 and 9 are the common cause and Shiodio which have been uploaded. My lord, this particular case, relying on A.R. Antule and P. Ramachandra Rao, my lord.
This is a
Supreme Court, my lord.
no,
It's two judge. But, my lord, they have interpreted. They have gone on to interpret A.R. Antule. They have gone on to interpret P. Ramachandra Rao, my lord, primarily. Because Antule was upheld in Ramachandra Rao. That's why I have placed this judgment, my lord. This is a 2008 judgment. Here they have played reliance on P. Ramachandra Rao, which has authenticated and which has upheld judgment in A.R. Antule. And following the principle laid down, my lord, the court here says at para 27, 28 and 30, my lord.
Yes.
My lord, page number 96, 97. If I may, my lord.
Yes.
Be that as it may, the prosecution has failed to show any exceptional circumstances which could possibly be taken into consideration for condoning the prolongation of investigation and trial. The lackadaisical manner of investigation spread over a period of 4 years in the case of this type, an inordinate delay of 8 years, excluding the period when the record of the trial court was in the High Court, is manifestly clear. 28. Thus, on facts in hand, we are convinced that the appellant has been denied his valuable constitutional right to a speedy investigation and trial, and therefore criminal proceedings initiated against him in the year 1987 and pending in the court of the Special Judge Latour deserve to be quashed on the short ground alone. Consequently, appeal is allowed in the proceeding against the appellant in so-and-so case are hereby quashed. My lord, para 19, if I'll sum up, my lord, on the law point. My lord, from para 18, the court starts at page 94, my lord. My lord, we
don't have time now.
My lord.
We'll continue tomorrow.
My lord, they've just they have defined how law says.
While you are at it, you might as well look up this case, 2012-8 SCC 495.
My lord.
You got it?
My lord. 2012-8 SCC 495. Because, my lord, I don't.
Ranjan Dravidi.
My lord, I'll come back prepared on that tomorrow.
You see what this court says here.
My lord.
Heard, Mr. Learned Counsel for the petitioner. Continue tomorrow.
Tomorrow? My lord, tomorrow. My lord, I'm fighting against delay. So for me, tomorrow is the fastest, earliest. My lord. Not because I don't primarily look to quash also, my lord. My lord, if the trial can, because I am 75, I have had 3 stents put 3 months ago. My lord, I don't want to go to my grave as an under trial.
See, Mr. That's what I said. After all, you have quoted so many decisions. True. We have to look and balance and see.
My lord.
But look at the case of the case I have referred to.
I will, my lord.
It's also similar. CBI matter, 302 matter.
My lord.
But the proceeding has continued for 37 years.
My lord. My lord, my
still allowed to continue.
My case, my lord. One day prosecutor comes. They don't have the key to the box. It's on record.
No. That see, the cause of delay could be due to the prosecution, due to the defense, or
my lord.
All those things due to the court.
My lord.
All those things has to be taken into account.
My lord.
But you see, at the end of the day,
my lord.
At the end of the day, let me be, candid.
My lord.
Prosecution cannot, the trial cannot be quashed.
My lord.
At most, the court can if I put the word implore also, maybe that would be correct.
My lord.
Can implore upon the trial court to take up the matter, in view of 309 and
my lord,
go on a day-to-day trial.
My lord,
otherwise, what else?
My lord, we walk satisfied with that.
If that is the case, we could have finished the matter,
My lord, because my lord, I am not charged under 302 also. I am charged under 201 and 203.
Whatever, but you are co-accused.
I am a co-accused, my lord.
Okay. See you tomorrow.
Hello, Miss, my lord.